Malheiro, Damien Geradin, Assimakis Komninos, thank you very much indeed for agreeing to share your expertise with us. We will be talking today about the Digital Markets Act, which is due to be published on the 12th of October. And we have a long catalog of different questions, problems, which are being triggered by this new legislation. And I hope, and I'm sure, that our viewers will have an ideal opportunity to learn from different angles, different perspectives, but from those three thinkers and actors who are not only active participants in the process from different sides, but also they have their views, they have, obviously they express their own views, and we'll have a healthy dialogue, hopefully, on various aspects of the DMA. Malheiro, let me start with you, and I wanted to ask you, during this journey, the DMA coming from the new competition tool and ended up with the regulation as we have it, it has been transformed several times. There were several paradigmatic changes. You work at the DMA task force in the Commission, so you have your own reflection, your own understanding, your own view. How are you satisfied with this final version of the DMA?
Many thanks, Oles. I think from the Commission viewpoint, it's important, the most important thing is that the key principles of the proposal were not changed. Of course, we know that the proposal was already the result of, it was not the initial proposal. You mentioned the new competition tool, but in Europe, decision-making is always complex, and co-decision is also a complex procedure. So the DMA is the result of this decision-making complex procedure. So this is just to say, in line with what you said, that it is the outcome of a process that involves many actors. Having said that, I think it's quite impressive that we managed to get this piece of legislation adopted in less than 2 years after the Commission put forward its proposal in December 2020. I think that's really quite remarkable, and in some way it shows that there is consensus around these issues in Europe. Then not so much going into what has been adopted in relation to what has been proposed. We could of course discuss that, but if we focus on what are the fundamental principles, they remain. So the Commission remains the sole enforcer of the regulation. This was discussed during the negotiations, and the principle remains. So that's quite important, also because it's an internal market proposal. So it's important that the Commission remains as the place to go for the regulation. Then the other principle that is quite important also for proportionality purposes is the principle that the DMA applies just with regard to a very specific list or closed list of CPSs. So that during the negotiations, web browsers and voice assistants have been added, but the list remains closed, can only be changed by a legislative proposal. Another principle is that it is an asymmetric regulation. It does not apply to any company. It aims to address a very specific problem, the problem that a small group or number of companies can act as gatekeeper for certain services, the CPSs. And then this gatekeeper position becomes very difficult to contest and enables these companies to engage in unfair behavior. So this is another idea is the fact that these companies have to comply with a set of obligations which are clearly defined in the regulation. In that respect is very different from competition law. So here the judgment about illegality has already been done. and the obligations are self-executing and directly applicable. So this also remains. And then, in addition to that, in terms of obligations throughout the procedure, there were not many changes. There were a number of obligations that were added, notably in terms of interoperability, mostly at the request of the Parliament. But for the rest, a number of changes were made in terms of procedure. The level of fines was added. The issue of the killer acquisitions was also addressed in different ways in two provisions. But for the rest, the key fundamental principles remain. And for that, I think for the Commission, it's a very positive outcome.
So if there is anything specific which has been dropped or anything specific which you would like to include, there is no technical norm or no provision which you are really disappointed with.
No, I don't think so. I mean, everyone will have their personal views, not specifically on the issue of obligations, certainly, but this is always the reason. The consensus is as it is. So, but the important is the architecture of this piece of legislation is maintained. So the rest, I think it's more a question of details.
So let me extend this question to Damien and Marcus, please. What, in your view, if you trace the evolution of the DMA, are there any aspects which, in your view, merit more kind of discussion or have been selected wrongly, etc., or have been dropped unnecessarily?
Marcus, you want to go first?
Happy to do so. I think that, the NCT, the new competition tool, was mentioned at the beginning. I believe that I don't think we should consider this a precursor to the DMA. I think, as it usually happens with the European Commission, it was a bit of an experimental, let's say, you throw a stone in the sea further ahead and you see the waves, and then then you can say, okay, I'm not gonna go as far as that, but maybe I can go up to the mid, let's say, distance. No need to go as far as that. And I think that this was just an experimental kind of consultation on the NCT. And I believe that while the NCT was discussed, at the same time, Commission was quite busy in terms of preparing the DMA. In fact, if you read this huge impact assessment study, that cannot have been done within a few weeks or months, let's say. This is much more, there's a lot of work behind that for sure. So I'm relatively happy with the DMA in terms of the final product. As Anna said, the very important issue was the issue of competence. The fact that we have exclusive competence for the European Commission in the designation, of course, but also in specification decisions, and also when it comes to decisional powers regarding non-compliance, that's sacrosanct. We have a bit more in terms of national courts. Now there's a provision on cooperation, duties for national courts. That's good. My views are relatively known. I wouldn't have gone for full private enforcement for the DMA, but it is what it is. And in terms of substance, I think it's a bit stricter. The intervention of the Parliament had this result. It's a bit stricter now when it comes to specific obligations, but nothing major in terms of the central structure of the instrument.
Thank you, Marcus. Damien, please.
Well, I think also I'm generally satisfied with the final product. It's one of these few instances where the final product is to some extent more stringent than the initial proposal. Usually it's the other way around, where the proposal is quite ambitious and then diluted. In this case, it's the opposite. So look, it's a complex piece of legislation. Of course, you can always criticize some parts, and have arguments that they could have been done differently. But overall, I think it's it's a coherent instrument. On some of the issues that have been mentioned, I mean, I think on designation, a mistake was made through the process, which is to focus exclusively on quantitative thresholds, because that means that some companies that have as little as 2% market share, I know we cannot speak about markets, but still might be captured. Unless, of course, they manage to offer a rebuttal. But once again, if you look at recital 23, it's quite limited. So I think it's a bit unfortunate, but time will tell if the Commission ends up designating companies that have little to do there. On the role of the national competition authorities, I mean, I could see pros and cons in terms of having them more or less involved. I mean, obviously, a good aspect of centralization is to avoid the nonsense of the GDPR, right? Where you end up giving enforcement powers to countries that are, too close to those firms that have to be regulated and may not have the right resources. On the other hand, I think when you look at EU competition laws, some well-resourced national competition authorities have played a useful enforcement role. And having spoken under Chatham House rules with a couple of, president of national competition authorities, they told me that they do not intend to play a significant enforcement rules because there's no point doing, the groundwork to then pass on the case to the Commission when it gets really interesting. So to some extent, I don't think we'll see a lot of work done by the national competition authorities, which is a bit unfortunate, considering that they have significant resources and they have also very good people. So yeah, I mean, there was a trade-off. In the end, it's going to be the Commission, and that's fine. I understand the trade-off, and I think the line has been correctly drawn in the end.
Anna, can I just forward this question or this kind of the thesis which has been just articulated by Damien about the single enforcement by the Commission? There are two kind of schools of thoughts. One would say that the key driver for this is uniformity, coherence, and the avoidance of kind of attempts to use kind of strategic litigation. Probably it's not impossible to imagine scenarios where one could try to engage in this. And another approach would be to say that because one of the drivers of the DMA was kind of procedural obstacles which the ex post competition law has created for the enforcer, or the interpretation of ex post competition rules that raised for enforcer. And the attempt was kind of to simplify the procedure and creating these low-hanging fruits with the abundance of opportunities to apply them. It requires some strategic planning. So it's not about policing of all catalog of obligations being enforced in their totality. It's rather more kind of smart approach to enforcing those obligations which in view of one enforcer are more important for broader societal or geo-economic interests than others. And if we just open it for national competition authorities, national regulators, and private parties, it will just create a hodgepodge of enforcement with only a little added value to this kind of broader goals. Which of these two approaches, in your view, are more relevant for the Commission?
Well, there were many questions in your question, but I think the regulation achieves a good balance in the sense that the ECN is also involved. We could not go as far as involving the national competition authorities because there was no political agreement to do so. So I think in the end, I don't fully agree with Damien's comment regarding the involvement of the competition authorities. It is of course correct that and understandable that many of them will rather devote their resources on their cases, but we also understand that other competition authorities were very willing to cooperate with the Commission at the investigation phase as well. So I think we'll have to see how things progress, but with the different institutional architecture that we have, and then see. But I think we have good starting points with ECNs, and as a starter with the Commission as the sole enforcer. So, and of course with the important role of private enforcement.
Can I just on that basis, Oles? I mean, and this is where when I hear that, I'm a bit kind of annoyed. I'm annoyed with all this emphasis on the enforcement side. Of course, you know, the DMA has to be enforced clearly, and there have to be powers, etc., etc., etc. But we need to think of the DMA not only in terms of enforcement. The DMA is primarily a regulation with specific ex-ante rules that is changing the legal reality. And this is the main purpose of the DMA. The DMA is not there to create another type of enforcement with fines every year, statistics, the GCR saying, oh, this amount of millions imposed this year, this year. It's not there to create institutions just in order to have institutions. It's there to change the conduct of undertakings. If we have a lot of enforcement, too much of enforcement, it means that the DMA has failed. So let's stop emphasizing the enforcement part, and also, and at the same time, emphasize really the ex-ante part of the story, that, you know, it has rules, per se rules. We may like them or not like them. They may be inflexible, which they are, but, you know, it has specific, very specific rules which are changing the legal reality. They're changing the conduct of companies. I have no doubt that the gatekeepers will comply. In fact, I know that they are already in discussions with the Commission, and also there's a lot of energy these days spent on compliance. So I have no doubt that they will comply. I mean, that it's clear. So to just think only about enforcement and, you know, compliance and who will do that, yeah, okay, but why do you want to go to the failure of the DMA? My emphasis is more on the success of the DMA, which is to ensure that there is compliance, that there is a guidance also from the Commission. There's some degree of dialogue between gatekeepers and the Commission, even before designation. I'm sure there are discussions. And this is what we should focus on, and not on enforcement. Finally, and I'll stop here, I don't think that the national competition authorities are left out there in the wilderness. I mean, I'm sorry, but you know, it's clear that the Germans got what they wanted. They can keep their Section 19A according to some. I have my own views as to whether Section 19A is lawful once the DMA starts to apply, but you know, but they will enforce their sui generis kind of rules, and that may create some issues in the future.
Okay, but let me react to these 2 points, if I may. I totally disagree with Makis, and obviously we represent different types of interest in this debate. I think enforcement is fundamental, and I think that the gatekeepers, or at least the biggest one, will actually not comply, or they will do what I have coined as a phrase with a trademark. They will constructively refuse to comply. In the sense, and you know, I've been battling Apple for many years now, and their strategy, for example, in the Netherlands, where they got condemned for abuse of a dominant position and ordered a remedy, is to introduce friction in the process to make it impracticable. So what we will see is an effort, not necessarily by all companies, right, but at least by some, to formally comply, right? I mean, or give the impression they comply, but actually not comply, in the sense that compliance will be organized in such a way that it will be unpracticable or unattractive by both business users and final users to take advantage of the new obligations. And it is literally certain that this will happen. I mean, look at the way remedies are typically applied or not applied or badly applied by the companies we know. And it will be a very heavy burden on the Commission to handle this lack of compliance. There might be circumstances where reasonable people may disagree on what compliance is. And I mean, obviously, there should be due process, and the Commission sometimes may be misguided, or third parties may have unreasonable claims or views. But at the same time, I think it would be extremely naive to believe that these companies with a history of making things difficult and dragging their feet will voluntarily comply. I don't think they will.
Let us transfer then to the legal side of this discussion, namely the anti-circumvention provision, which probably would somehow reflect the motivation. Its motivation actually reflects the concerns which have been just raised by Damien, that you can, 1001 way, being the super heavyweight, the most skillful kind of agenda setter in our digital world, 1001 way to comply with the letter without complying with the substance or the intentions. And then we enter into very kind of shaky area of anti-circumvention provision. The original version of this clause reflects kind of that the company has to comply with both the letter and the spirit. And then at one of the versions, I think it's at the Parliament's version, it has been transferred, it has been moved to Article 6A. And thus non-compliance with that it was kind of seen as one of the obligations, and thus would be the company would be liable essentially for meeting the letter of law while not meeting the intention of the legislation. Does it sound a little bit paradoxical from purely juristic logic, so to say? Obviously, we don't have it now. It has been kind of refined back to more intention or the message to the gatekeepers. Does anybody have any views on the role and the idea of anti-circumvention clause?
Well, if I would prefer not to make a comment at this stage on the previous versions, because sometimes it's surprising. It would be a surprise to know why they actually are like this and like that, and the reasons are not necessarily so intentional as one may think. I think that what Damien said is, of course, an important point, and in the discussions during the interinstitutional negotiations, anti-circumvention was extremely a great concern for everyone, because obviously of the past, of the history many of these companies have of not complying and of adjusting and, as Damien said, constructively complying to legislation. So I think to put I mean, of course, that I think the regulation aims to address that, and the Article 13 with anti-circumvention is, and there are a number of other provisions that indicate that the possibility of circumventing was in the mind of the co-legislator. For example, to start with the designation procedure, Damien, you were saying that you were worried about the false positives. The Commission is certainly also worried, but at the same time, you have to balance what is more important, to address the false positives and keep them out in a very categorical way, or make sure that you create the presumption or the possibility for companies to come up with a rebuttal is not a easy one. That would make, again, allow for companies to engage in delaying practices and making the Commission to state the obvious, and which we have been doing for the past years. And I think that was the aim. But there are also other elements, for instance, the very principle of Article 18 and the idea that systematic non-compliance is to be found where you have 3 non-compliance decisions. This also indicates that, well, where the Commission sees that there is systematic disrespect, but the very Article 13 is constructed in a very, very broad way. It covers all type of behaviors, contractual, commercial, technical, or any other. And I think the hopes of the Commission is that companies will understand by this that it will not be easy to circumvent. Having said that, this is obviously a very technical sector, and we are aware that we will have challenges, but
is it justiciable? Can you enforce this provision? There's no, I believe there is no liability, or I might be wrong on this, for circumventing the essence of obligations.
Well, the Commission, they may adopt a specification decision attached to Article 13, and this already is takes the form of a decision. So I think that was the way.
There is liability, Oles. There is liability, because this will be read in conjunction with Articles 5, 6, and 7. For example, if the Commission says you're not complying with 5.3, in conjunction with Article 13, because so it's not that the Article 13 cannot be enforced. I mean, it can be enforced clearly.
Okay, so basically, it's broadening further the scope of obligations of Article 5, 6, 7.
I wouldn't say that.
No, I don't think so.
No, that doesn't.
It makes it clear that a company cannot easily, the company needs to ensure effective compliance, putting emphasis on effective. And the Commission will have the tools to prove that effective compliance is not being complied with if the company is engaging at any stage, be it the notification level or compliance, is fooling the enforcer around, basically.
Okay, so it's about kind of subjective intention to circumvent rather than circumstantial implications of a specific business conduct. But let us move now to the issue which I think Marcus has mentioned in passing, that the gatekeepers are prepared to adapt to the new reality and to comply in full. And obviously, when during the beginning of the process, we had this idea of participatory in antitrust being, vocally present in different discussions, and now we often hear this idea of regulatory dialogue. Obviously, we understand that some obligations of DMA are supposed to be self-executing, others are susceptible to being further specified, and I applaud to the person who has designed this term. So how, in your view, would this regulatory dialogue be, seen in practice? Maybe we can start from Damien.
Yeah, I mean, to be honest, I don't know. Well, I suppose that, companies are working on compliance plans. I know they do, right? I mean, even if they want to defend their interests very strongly, they still need to work on compliance. And, the very big gatekeepers have a lot of work to do, right? I mean, if you have several core platform services, adjusting to the new rules is a lot of work. So I assume they will have compliance programs in place. These compliance programs will need to be shared with the Commission, but there will be a number of questions. And some of the obligations, even when they relate to Article 5, are not necessarily clear. And then some of Article 6 also deserve some discussions with the Commission. And my understanding of the regulatory dialogue, although it's limited to 6, but I suppose it could be also, you could have some form of dialogue on 5, right? Is that there will be a dialogue between the Commission and the designated gatekeepers to try to make sense of these provisions and how they apply to the companies in question so that they can, you know, comply to the best they can, assuming they want to comply, of course. So that's how I understand the regulatory dialogue. Now, if you look at the text of the DMA, it's not explained how it will take place in practice. Will there be guidelines? I don't know. So I suppose Anna has probably a better view on how this is going to happen than I do.
Maybe, thank you, Damien. I think one has to maybe distinguish what is the regulatory dialogue under Article 8.4, which we now call process. But we all know it's the former regulatory dialogue. And for the purposes of getting a specification decision from the Commission. And that's a very narrow interpretation of let's say, the main message there is, is the Commission obliged to engage in such regulatory dialogue? No, it's not. It's a prerogative. And can companies expect specifications and decisions? No, it's also prerogative of the Commission. So this is, let's say, the very legalistic viewpoint. This is one thing. The other thing, and I think you were pointing to that, Damien, is indeed this is the companies are responsible for complying with the obligations of the regulation as of a certain point. So by spring 2024, by this deadline, they need to have business models, compliance programs. This requires changes in many things, the way the companies organize themselves, the way they process consent, the way they sell products. It's a complex exercise. We are aware of that. And this means the Commission needs to, and the companies, that we all have an interest in cooperating as early as possible. And indeed, you are right, the Commission is already in contact with a number of companies who came to us to have advice at the first task will, of course, be the designation. So at this stage, companies are already seeking advice, because it is their responsibility to notify and to designate what are the CPSs where they consider that they meet the thresholds. But it is the notification, the Commission is working on a notification form that should be ready towards the end of this year, will be submitted to public consultation. This notification form should serve as a guide. From that, there will certainly be questions from companies. There are already, but let's say we will probably engage in a more, I would not say a formal way because it's not formal, but in a more active way, possibly, with the companies to provide feedback on what is the draft, would be their draft notification. So the earlier we get what could be their draft notifications, the better it is for everyone. So this is the state of the designation. And for the state of the compliance with the obligations, which is indeed more complex, on that we will need to involve other market participants, obviously. We will have to market test the compliance, many of the proposals. Third parties will also be involved, and the Commission is already organizing technical workshops on a number of issues that I believe will take place still before the end of this year, to exchange views with companies and third parties and potential gatekeepers on what their views are on specific issues. So this is indeed, it should be the result of the main message from the Commission side is that the door is open to engage in a positive way. The earlier, the better.
Although if I may ask, my understanding of the Commission's approach is really to focus on designation initially, and then once the sort of designation part has been sufficiently progressively start discussing obligations, or are you already discussing obligations?
Sometimes it's difficult to disconnect one from the other because right. So the idea is indeed first to focus on designation because that's the most pressing. Having said that, we have to deal with some obligations and how to implement. But for the priority is designation and delineation of CPSs.
Okay.
Just one point on the regulatory dialogue or the guidance or whatever you call it. This is only, formally speaking, for Articles 6 and 7. But in my view, I mean, I'm sure one could say that there will be an informal regulatory dialogue or guidance also with regard to Article 5. Now, I hear sometimes the distinction being made between self-executing Article 5 and non-self-executing. Well, no, everything is self-executing in my view. I mean, and I'm speaking here as a lawyer, right? It's clear that all the rules are self-executing. The specification measures of Article 8 do not change the substance of the rules. This is not like the, if you want, it's not like the notification, the exemption decisions in the old days or before 2004, which were going really to the core of the obligation, right, of the rule. Here, the rule is clear. What, however, we have with Article 8 is about only the compliance measures that the Commission believes should be adopted by the companies in order to comply with the rule, which is already there. The rule is not changed by the specification measures, right? So we need to make this clear, because I hear a bit there is some confusion. So all the rules 5, 6, and 7 are directly effective as of February 2024. They will be applied in court. You don't need a specification decision, for example, for a court to apply Article 6, 3, or 4, or whatever. Just so,
Makis, if I may ask you, what you're saying is very interesting. So this sort of distinction between Article 5 and 6 is not really meaningful in your view.
No, it's not. First of all, I don't understand why 5, I mean, why the specification measures are not open to Article 5. I'm sorry, but if any person can tell me, and in a persuasive way, I'm happy to, but I don't see any. So we shouldn't, this is a theoretical issue. I mean, clearly from a practical perspective, all rules will be directly effective as of February 2024, and yeah, okay, formally speaking, specification decisions we will have only for Article 6 and 7, but I'm sure that there will be dialogue also with regard to Article 5.
But isn't it also the case that we could apply the obligations of Article 6 ex tunc and ex nunc? So if the consensus is reached between the parties of the dialogue, then the new refined interpretation of this specific provision of Article 6 would be applied, and that's narrower. And obviously, the broader provision would be still binding from purely juristic point of view, but then somehow it will be much more difficult to enforce for the Commission after agreeing within the specification procedure the narrow interpretation of Article 6. And so with Article 5, we don't have this.
What do you mean by narrow? Or there is no narrow, or I mean, I'm sure the Commission will want to have full compliance with a particular obligation in Article 6. I don't understand what you mean by narrow.
Okay, let us then move, if I may, to another aspect of this, of more kind of participatory model, the mechanism of commitment. So we obviously understand that in 99.9% of the cases, the gatekeepers will seek to comply, but once instance of non-compliance is established, there was again, Anna, I note your reservation of it's complicated and unnecessary to talk about different versions of the DMA, but still the mechanism of commitment, if I may ask you all three of you, it has been transformed slightly. Yeah? So now it has been narrowed down. We can only apply it to instances of systematic non-compliance. Does it make any significant difference, or it's purely, again, purely technical matter?
So basically, indeed, there is a quite substantial change in there. I think the concern, this was actually the proposal from the Parliament side. The concern was, again, in the logic of avoiding circumvention, that you would allow for companies to commit and thereby avoid a non-compliance decision. And this would delay triggering any potential Article 18, the systematic non-compliance, and so which it gives considerably more powers to the Commission by giving the Commission the possibility to impose structural and behavioral remedies. So in that spirit, the co-legislators agreed to restrict the commitments only to market investigations to establish systematic non-compliance. This means that, I believe in practice, what will happen is that only at the moment when the Commission is discussing imposing or considering imposing behavioral or structural remedies, at that stage, the procedure could end, instead of ending with a decision, could end with a commitment. So that was the very logic of it. So indeed it changes, but the co-legislator, the perception was that it would make the DMA stronger.
Don't count, Oles, that this will ever be enforced. I don't think that this article will be enforced ever.
The commitments, or the article, or the
commitments? I mean, the way it is now. I don't believe that.
Can you elaborate on your skepticism, or
no, because it's a very exceptional scenario, very far-fetched kind of scenario, which I don't believe we will ever have, to be honest.
Would it be different if the version in the previous version?
The commitments provision, I mean, was always a bit intriguing to me when I first saw that, because it was kind of, I mean, you have the specification decisions where essentially are the results of a specific dialogue, and then you have suddenly the commitments decisions, which would have been coupled with non-compliance proceedings. I mean, I always thought that their scope would have been rather limited in the DMA, to be honest. Do not forget that the commitment decisions in antitrust are about essentially specific remedies that need to be adopted in order to comply with general clauses in the treaty. Article 102 is a general clause. Article 101 is a general clause. There's nothing specific in 101 or 102 to tell you have to do this. So, the remedies are either imposed by under Article 7, and the Commission usually avoids becoming too prescriptive when it comes to Article 7 remedies, or they are the result of a discussion and the result of a settlement under Article 9. And so I can see the usefulness of commitments in the antitrust area, but the usefulness of commitments in the DMA, where we have very specific rules as to what exactly needs to be done, is relatively reduced, I would say, if you were to compare it with antitrust.
Maybe if I could go back one step, and that relates to what Anna said about the participation of third parties and market testing. So I think that will be something of interest to many third parties, right? Because of course they will want to have their say and make sure that the way a given provision is implemented is effective. So Anna, will there be a sort of systematic market testing, or will it be sort of more spotty depending on the circumstances?
I don't know if I can already reply to you at that. At this, I could imagine that everything will be tested. The more technical it is, the more we need to test it. That's so. I don't think that there will. So it depends on if it's very obvious and straightforward. It does not need to be tested, but.
So when will the testing take place? I mean, is it before a sort of specification decisions? I mean, I'm just trying to better understand the sort of mechanics of it. If you know,
the market testing. I mean, the market testing is not in the that I was referring to does not refer specification decisions. This would take place only at the very latest stage when the regulation enters into force. Okay. I mean, so this informal market testing without specification decisions would rather refer to this stage of the procedure. So already ahead of the notifications, when companies are working on their compliance compliance systems in their companies. Okay. And so here we even invite companies to proactively come to us, or third parties, associations that represent the interests of several. So everyone is very welcome if they have views already. As soon as we can, we would. But this is not. This is still being considered. But as soon as we can have, let's say, disclose something to be tested, we would do so. But we are still, I mean, companies still have not approached us with everything. So they're also engaging in brainstorming if this is possible or not possible. So, but it will be before the notification takes place, to my understanding. But yeah, I think this is what will be done.
Okay.
I see we're moving closer to the end of the hour. There is obvious appetite for the discussions about nebis in idem and issues of parallel enforcement and of the rules which sound identical but might appear different, etc. Does anybody want to reflect on this aspect and maybe also include private enforcement? We have touched upon this issue in passing earlier, but if there is something which requires further specification, I would welcome your comments.
I can say something about non-bis in idem. I do not think that non-bis in idem will be a major issue vis-a-vis DMA enforcement. First of all, when we talk about non-bis in idem, we mean non-compliance decisions, because these are the ones that can lead to fines, and therefore this is the quasi-criminal part. Everything else, non-bis in idem has nothing to do with, right? Let's be clear. So the non-compliance decisions can lead to fines. So that's one possibility. And then you have the possibility of the Commission opening competition law, abuse of dominance, for example, proceedings. I don't believe that this will ever happen. So the Commission will have to choose at some point whether to go for competition or DMA. Where the problem arises is if, for example, you have a non-compliance decision under the DMA rules by the Commission, and then you have the Bundeskartellamt taking an abuse of dominance decision under Section 19A, and Of course, as a first kind of level, there will be no fines, but if there is non-compliance with that decision, there will be fines. And then the non-bis in idem could arise there, I mean, in that particular situation. But we shouldn't be worried so much about non-bis in idem. We should rather be worried about this scenario taking place in the first place. You know, this is something that I would consider totally detrimental to harmonization and to the objectives of the DMA, which was to avoid fragmentation. So before even speaking about non-bis in idem, I would rather not having that scenario at all.
I tend to agree. I mean, I think in the best of worlds, we would not wish to see a section 19A, right? I mean, why is there one, by the way? I mean, what's the purpose? I mean, I can understand politically that the Germans want to have their little toy, but if the idea is centralization and coherence, it's peculiar. Now, I suppose that some of the problems can be avoided through the ECN. And I think that Anna was alluding to that, saying there will be cooperation with national competition authorities. And I suppose that cooperation with the Bundeskartellamt will have to be, well organized in order to avoid this sort of horror scenario that Makis is talking about. I agree. I mean, that would be very unfortunate to see, the same behavior suddenly being prosecuted under different sets of rules by different institutions. That would be chaos.
Yeah, I think that was certainly not, the Commission was also quite worried of the B post judgment, which I believe came out during the interinstitutional negotiations. There is also a recital expressly tackling the issue of the non-bis in idem and the issue of fines, and that if there are fines on other imposed on the same legal person for the same behavior, that this will be reflected on the level of fines. On the one side, for the other side of the harmonization, there is a system in the regulation that relieves the national authorities from the competence to pursue cases. We will have to see how will this work in practice, but the system exists. So we have to see, but indeed, through the ECN and I think everyone is in agreement that that's not desirable, and that's also not the intention. But I think we have the necessary tools to avoid that.
Yeah.
You are referring to 11 paragraph 6 of Regulation 1/2003, right?
Excuse me?
You said we can withdraw a case. You mean you're referring to the Article 11, paragraph 6 of Regulation 1/2003?
No. Regulation 1 does not apply. I'm referring to the DMA. You cannot
withdraw a case if Bundeskartellamt brings a case under Section 19A. You cannot do anything.
No, it relieves the national authority of their competence. I agree that how this works in practice in the framework of the ECN, it is also not easy under Regulation 1, but there is a provision, I'm trying to find it in the regulation, which also says expressly that competition authorities are, that opening a case by the Commission relieves Sorry, I was not prepared to do paperwork while
maybe while we post on this, maybe we can somehow reflect. I hear the logic that they say, okay, if it, as the DMA is about contestability and fairness, rather than it sounded for many as a purely kind of semantical discussion, but we can see instances where it can be really relevant. So what's in your view, Damien? What in your view the difference between contestability and competition? Is there any meaningful difference between these two terms? Competitive process and contestability?
Well, it's a good question. I mean, I suppose that, there is an effort with the DMA to distinguish itself from competition law. right? I mean, the sort of concepts that are used in DMA are not the same. And it's on purpose, right? You want to avoid a scenario where you have to define markets and then have a theory of harm and show the effects because it's time consuming, it's extremely complicated, and so on and so forth, right? So I suppose that, you know, when we speak about the objectives, they have to be a little different as well. Contestability, I guess, would mean that, you know, it's not, I mean, markets should remain open, if at all possible, right? Digital markets should not be locked. That's what I would understand by contestability. And I suppose that some of the obligations tend to go in that direction. If I think about app stores, you know, that's one thing that comes to mind. You know, you have a provision saying that, you know, third-party app stores could not be prohibited, and side loading could not be prohibited either. So that should open mobile ecosystems, right? Make them more contestable. Whether it will work in practice or not, it's a different question. But I can see this sort of obligation tying to this objective of contestability. When it comes to fairness, well, that's a term, of course, that has always been complicated, right? What is fair? But I can also see some obligations then to be tied to that. I mean, if you look at Article 612, which applies to some core platform services, you know, access should be granted at fair, reasonable, and non-discriminatory terms, friend terms. So obviously, you know, that seems to be linked to the objective of fairness, right? So, I mean, I suppose that if you look at the obligations, many of them will be linked to the notion of contestability, keeping ecosystems open. Some of them will be more on the side of fairness, and others might not fit within either concept. So that's basically my general view.
And I assume we are all in consensus that dropping out welfare and innovation is the reasonable thing to do. Before closing this really impressive session, Anna, yes, go on, please.
For the sake of
so coming back to Article 19.8.
No, 38.7 would be the but just for information, since I know you are editing this.
Yeah, on that point, and perhaps we can avoid, but on that point, my point is essentially that you are referring to a very specific scenario where the Commission opens proceedings for non-compliance proceedings. That's one scenario. But what I'm saying is a different one. A company complies with Articles 5, 6, and 7. You are fine with it. And then suddenly the Bundeskartellamt opens non-compliance proceedings on Article 19A. That article that you just referred to does not apply, cannot cover.
But then you also don't have an non-bis in idem problem.
No. The non-bis in idem is a different issue. I mean, it's a different issue that we already discussed. But what I'm saying is that you cannot withdraw, or I mean, initially, I believe there was a proposal maybe by the Council or the European Parliament there was a proposal that was not adopted essentially, but
there was a veto right.
There was a veto right, exactly. But here, I mean, the provision that you're mentioning is only if you want to introduce non-compliance proceedings, okay? But the harm already happens if a company complies, you're fine with it, and then I don't know, the French authority of the Bundeskartellamt based on a specific rule says, no, it doesn't, we don't care about 5, 6, and 7.
You already have that for 102, where the member states can also go beyond and be stricter than right? They can have national laws that are stricter than.
No, clearly that's true with regard to unilateral conduct, but I'm talking about Section 19A here. Which is a very sui generis competition law statute and echoes a bit the DMA. anyway, I'm sure all these questions we will end up in courts and we will have interesting discussions.
Makis is already getting excited with, court cases already.
Yeah.
I'm getting scared.
I have two questions left. First, I wanted to invite you to comment on issues which, in your view, appear to be very important, or you wanted just to make a note on them related to today's discussion, which have not been addressed, or maybe you wanted to add something as A, and B. Obviously, you are established stellar participants of this process. But remember that the DMA, we hope, will last for quite a long time, and there will be new generation of your peers who will be also involved, and they are now sitting in their dormitories or their virtual garages, however you can phrase it. Can we just give you genuine tips and suggestions what their focus should be, what should be avoided, maybe how they have to somehow use their limited sources in the most wise fashion? So let me start with the first part, inviting you to reflect upon issues which have not been mentioned and which are relevant for today's conversation, and then we'll move to the second one, please.
I was actually very curious. I was on a listening mode for the private enforcement. I don't know but I would be curious to hear what.
Yes, I'm happy to. This is my kind of.
That's your stuff.
Yeah, that's my stuff, and I'm happy to. So we have a problem with the DMA. The problem is this. First of all, there's a paradox here. The paradox is that we want not to have fragmentation. We want to have harmonization, centralization, etc. So we exclude the 27 specialist authorities, but at the same time we open it up to thousands of generalist courts in the EU, essentially, who tomorrow can take a decision as to whether, for example, there has been compliance, or I don't know, a particular GAFA or a particular gatekeeper. We should be using names, although we, as Thomas Kramler once said, it will apply to a handful of companies. But anyway, so a particular gatekeeper is not in compliance, right? And then suddenly the judge in Helsinki, in Palermo, in Athens will have to decide essentially whether that particular gatekeeper is or not in compliance with a particular obligation. So I mean, as somebody who has also done my PhD in private enforcement, I mean, the common mistake that we do with private enforcement is we tend to identify it as with follow-on damages actions. Private enforcement is not only about damages actions. Private enforcement is about injunction cases. And in this particular respect, injunction cases cause most of the problems, because you will have, as of February 2024, you will have claims put forward before national courts where particular plaintiffs will be saying, I don't care what the commission has agreed informally or with that particular gatekeeper. I read paragraph 6 or whatever of Article 6 in a particular way, and this company is not in compliance with that particular provision, right? So you will have essentially chaos, because you will have potentially judgments ranging from Lisbon to Vilnius, and you may have judgments which are taking erratic approaches vis-a-vis interpretation, and also injunctions, specific measures that have to be applied. Such judgments, of course, will have res judicata effect inter partes, between the parties, whereas if a commission takes a specification decision, it will have erga omnes, general kind of validity. But still, I mean, the risk is there. And, I don't know how you're going to be dealing with that, but I can tell you this is a serious risk of fragmentation in the internal market.
Yeah. No, I tend to agree, and let me combine two issues. One is enforcement by the Commission, and then private actions, because I think the two are linked. So my experience, advising defendants, although in digital markets I tend to be more on the complainant side, is that complainants, they always try to look for avenues to be heard, right? And sometimes you reach a dead end with the Commission or with a national competition authority where you have filed a complaint and then nothing is happening, either because the complaint is not good enough or because the Commission doesn't have the resources. So you're looking elsewhere. And if you think about competition law, well, the elsewhere was typically the national competition authorities, right? I mean, you file a complaint to the European Commission, nothing is happening, then you go to the French or the German or the Dutch or the Spaniards or Italians, right? You have private enforcement as well, which, you know, can be explored, but less so. Now, with the enforcement of the DMA, we have the Commission, which will be understaffed. I'm sorry to say it will be understaffed because it's a lot of work, right? I mean, let's face it, there are many potential gatekeepers and there are many core platform services. So however you look at it, it will be a lot of work. These people will be very busy and, you know, probably swamped. Okay, so sometimes, or sometimes or often, we don't know yet, right? Third parties will get frustrated. And then they will seek for other avenues. Going to a national competition authority may not be the best strategy, although Anas is saying that some of them will want to help, probably some of them will want to help, I hope so. But if not, an injunction in court might be the best way to go, right? Now, will it create a lot of sort of inconsistent decisions? Hopefully not. I suppose that the courts will make good use of the preliminary ruling process because it's all novel. They will have, I mean, the judge in Vilnius or in Palermo will have very little to draw on, right? So it might actually be quite helpful to build a case law or the case law around the DMA, right? What would be unfortunate would be to have a judge shooting from the hip and taking what is effectively a stupid decision, right? But I hope that they will be wiser than that.
Anna, what is your view, or can you reflect what's the atmosphere about the role and place of private enforcement of the DMA in the task force?
I think there are a number of, I agree with everything that has been said. As to the option, I will not make judgment about the option in the sense that it's there, so we have to deal with it now. There are the possibilities for preliminary rulings. There is also the cooperation mechanism between the Commission and courts that also works in the ECN framework. So I think it's law enforcement.
Marcus, I recollect your argument. At some point you made it that we have to be vigilant about and make it, remember the basic difference between direct effect and direct applicability, and not to confuse these two terms of EU law, and that not all directly applicable provisions of the secondary law are necessarily directly effective. Can you elaborate on this, please?
It was an argument that I was making at that time. Now it's too late. Of course, it was an argument to say that the fact that you have a regulation and there is case law that the regulations are directly applicable doesn't mean that the legislator cannot limit the direct effect of certain provisions. And I have written about that, and I have given examples where the legislator restricted a bit the direct effect. And I was supporting the view that if I were the legislator here, I would restrict standalone litigation, and I would limit private actions to follow-on claims as soon as there has been a decision by the European Commission that there has been non-compliance. But that's now too late, and that's very theoretical. My only plea to the Commission is let's see, maybe I'm exaggerating, maybe I'm wrong, and maybe, those who are saying you are exaggerating are right. But if we see that this system is starting to show signs of fragmentation because of national courts, I would plead to the Commission to start taking a more active role in terms of amicus curiae and intervening before the national courts, even, informally writing to gatekeepers or companies and saying, in our view, if you are doing that, we think sort of comfort letters that could be used before the national courts, and do that more actively than in antitrust, because we have had this tool for 20 years and has been used maybe 20 times. So, it's not a very successful tool. As for preliminary references, how many preliminary references do we have in competition law every year? I think it's about 8. So, maybe less. So, it's not, I don't think that these are the solutions. But let's see how the system develops. And I would plead to you to be open-minded and consider these options to intervene in such cases.
So other relevant issues which colleagues wanted to ask maybe each other or to reaffirm? In this case, let me just ask you, please, to provide your kind of the algorithm of success, to disclose the algorithm of success for the newcomers in the profession. What would be your golden
in the legal
recommendation? Legal enforcement. All three of you are, you are sitting on the right answers. So we invite you kindly to disclose part of them, at least for current students and those who will be active in this field in the future.
Well, I can start maybe. So, look, I think it depends a little bit what you want in your life, right? And obviously, Makis and I know Anna a little bit less well, they've always been quite ambitious in the sense that, we're practitioners, but we've been writing extensively. And I think that being more than a simple practitioner is a good thing. Building your own reputation is a big thing, because otherwise you're essentially a widget, which can be replaced very easily. And so, I've never really worried about what would be the next steps, because I thought that I was having enough visibility. So I know that the tendencies these days is or maybe, firms are getting larger and it's becoming more difficult for young lawyers to build their own, visibility and their own brand in a way. But I would encourage them to do that. Now, there's no secret. It's a ton of work. I mean, it's a lot of work. I've worked extremely hard all my life, and I keep doing so. So it's not an easy subject. And if I compare things today with things 30 years ago, when I started 30 years ago, judgments were few and they were short. Same for commission decisions. The sort of regulatory framework was thin. Now, there's a new proposal every day, it seems. The judgments are getting very long. Look at Android, 213 pages, and you have to read that on top of your daily work. So I would advise people to build their own brand, to be visible, because also you will enjoy more the profession. But unfortunately, increasingly, it requires a lot of work. Thinking that you will just, cruise along, your professional life is a bit naive, or you have to revise your ambitions downward.
Yes, I agree entirely with Damien. A piece of advice also for those that want to become lawyers, but also for those that want to work in this area more generally. the area of competition law, or this kind of tools, the new kind of the new world of the DMA, the foreign subsidies, and all this kind of new areas of enforcement, always take a step back. These are technical subjects. Don't get into this microscopic type of analysis and, you know, knowing everything with this or that particular question, etc. That's wrong. You're losing the broader picture. Always take a step back. Have some sympathy for what you do. Try to understand people and practices and conduct, etc. Don't be biased. Be open-minded, be rigorous in your analysis, but always take a step back. Otherwise, it will become really a kind of micro-scientific area, which shouldn't be.
Just very broadly, what I usually think for myself is always understand what you are doing, in the sense that sometimes we just take it. What is a 102? I remember thinking for months long, what is a 102? What is an abuse, and why? Until I understood, well, it can be everything more or less. But so first understand what you are doing, because if you don't understand, you cannot bring added value to anything. The second is, because the day is only 24 hours, as Damien said, this is a very hard working type of profession, and unfortunately it's not just the private sector, the public sector as well, at least here in Madhu. So because the day has 24 hours and because there are plenty of wonderful things to do out there, make it worth it and meaningful, and start thinking by what am I achieving with this? Is it worth it? If not, just reverse engineer and don't devote too many efforts on that. So be a bit results oriented. Is it? And I think in the public sector, it's very important to continuously asking this, because sometimes resources are limited, and if you are devoting resources, time, money, to come up with something that in the end brings nothing or is eventually quashed, then it's a waste of time. And finally, have fun. I think it's quite important to be motivated and to have fun in doing this. If you're not having fun, then it's really not worth it, I think.
Imagine. Thank you very much indeed, Anna, Assimakis, Damien. It was a pleasure talking to you. Thank you for sharing your expertise, your wisdom, your goodwill, and positivity with all of us. I hope we'll have an opportunity to discuss it further at some time in the future. Thank you.
Thank you so much to you.
Thank you.
Thank you.
Bye-bye.